So today I would like to discuss specific aspect of EB-5 immigration program, particularly concerning the USCIS guideline and their action regarding the Vietnamese investor. Many investors are recently currently residing in the US, and they already filed their I-829 for several years ago. And recently, we have noticed that USCIS requests them to provide the more documents on the past of the fund. So, could you please share with us, like USCIS, why USCIS would like to revisit this document again at this stage?
So I think maybe we step back and talk about what the 829 really is for, right? The filing. And so the EB-5 process is a green card process by investment, right? And the receipt of full permanent residence is dependent upon, of course, the creation of the requisite amount of jobs. And so initially, after the EB-5 petition is approved, the investors then go on to get their conditional residence, and when that is approved, it's valid for 2 years. And 180 days prior to the end of those 2 years, they can initiate the 829 filing. And the 829 filing removes, the approval of the filing removes the condition on permanent residence, subject to meeting all of the requirements like the job creation and all of those other things. And as you said, recently, and previously, really those 829 petitions, well, first of all, didn't take quite as long, but second of all, were fairly straightforward business where they would look at the job creation, right? They would look at, sometimes the investor's presence in the U.S. and whether they maintain their presence or if there were some sort of criminal issue. So normal things that the agency would look at in this process, and they would approve the 829, and they would remove the condition. But more recently, first of all, the processing times on the 829s have increased exponentially, right? To now, we're seeing insane wait times on those, like 6 years, processing times that the Immigration Service posts. Sometimes you think they must be joking, but they're not joking. This is actually how long that they're saying it takes. And on top of the longer processing times, they have started issuing these requests for evidence that are reaching back to the time of the initial investment of the funds, and are asking questions about both, we've seen the source of the funds and the path of the funds into ultimately the project, right? And so why is this really happening? I think one of the reasons does go back to what I said before, and that is probably somewhat of a training issue for the officers looking at it. As sort of I said earlier in our conversation, probably not a lot of experience with these issues for newer officers who are taking the opportunity to reach back to things because they don't know the true purpose and, legal requirements surrounding the 829. But also, there is a fair amount of that the policies of adjudication have changed a lot since the time that the 526 petitions for those investors now having their 829s in the queue were approved. And there may be a sense at the agency that those approvals that were gained many years ago were done with a lot less review and a lot, less time taken by the officers to look at everything that was required and whether it was included or not. And so, we do, when we are working on these types of requests for evidence, we of course go back to the, with our response and say, this was already adjudicated, these are issues for the 526 process, but at the same time, there are regulatory provisions that are not necessarily just EB-5 specific, but overall for adjudications that give the Immigration Service the ability to reach back to these types of things if they cite to those provisions, okay? If they say that they have fraud concerns or something like that, they can go back and ask those questions. So while it is an absolutely valid concern about training issues and wanting to educate the agency about this process and how it should work and how adjudications should go, these requests for evidence should be treated seriously and responses should be prepared thoroughly. Obviously, we're talking about information or events that took place many years ago at that point. And so it can be really hard to document these situations, the path or the source of the funds, the way that you would when it's just happened, right? But the best possible effort should be made to put together the documents that were perhaps already included initially and gather as much as possible. And this is where working with the right attorney is really important, because it's a matter of sometimes being creative and thinking about what will work. Okay, so we don't have this, right? But we might have this, and this could also work in a way that, it's not as good as a direct piece of evidence, but it can point to the lawful path of funds and can really provide kind of an overall explanation. We have been successful in getting sort of as much as possible put together. And again, maybe it's not like it would be if this was a new 526, right? Because those things would have just happened. But with some work and some looking at what the questions are and what the path or the source of the funds was and what we can provide now, and putting the arguments together, we can be successful, and we are successful in our responses so far, yeah.
I see. So let's have an example. For the investor who already filed 829 and waiting for adjudication. As you said, this happened is maybe like 6, 7, 8 years ago. So what if they cannot provide any additional document, any additional information to respond to the RE?
Right.
So
it really depends on what we're talking about. So for example, let's talk about if this is a request for evidence on, say, like the source of the investment funds. And say the Immigration Service says, oh, well, we see that the source of your funds is you sold this real estate property and you gained the funds to invest into EB5, but just, 10 or 8 years prior, this investment, this property was worth, this much, and all of a sudden you're trying to claim to me that, it's worth is enough for you to make the EB5 investment, and we don't believe you, and how is it so fast, things like that. And perhaps no more than what was already submitted is available, because what else can you give at this point? So we would provide, articles that talk about the increase of the value, right, that happened over the course of truly just a handful of years. And that was very, very sharp, right? And it's really not specifically about this property, but it sheds light upon why this property 2 years before, 3 years before, whatever, was worth a tiny percentage of what it was worth at the time that it was sold. It makes sense. We give background for the situation, right, for the facts, plus the documents that were already submitted previously. Similarly to, the path of the funds. And, again, caveat, little note here, right, that, there were some cases, and we have seen that were filed some years ago with really not a lot of evidence. And maybe at the time, whoever the lawyer was for, that case could have gathered a little bit more and made it a little bit stronger, but for whatever reason did not, do that. And so, and those can be the cases that are really, at risk the most for our fees at 8 to 9 stage. And so we really need to see what we have for the path of the funds. And if this is a licensed exchanger situation, we have developed a whole score of legal arguments and legal documents about why this is entirely legal and appropriate process. And perhaps even if the additional documents from the individual aren't available, we have those documents to add.
So I saw many cases that do the money transfer back in like 2012, 13. That they use the money transfer agency without money exchange license. So So that's why they can't provide any. So what is what circumstance happened to those investors?
Well, so we have had, obviously we have seen those RFEs as well, and we have gone back to the investor and tried to have them get in touch with those individuals and really get, as the most basic documents that they can on even trying to shed some light on the source of the funds of that person, and say, this is all that is available, and argue why this is sufficient, and go back to that the 5 to 6 was approved, with that information. And if this is all we can do, this is all that we can do.
So, what if the USCIS adjudicator is not happy with this document because the investor cannot provide the requested document that led to their 829 petitions ED9? What happened if the 829 application ED9?
So we have not really seen that happen on that basis just yet, but I think one of the things to talk about is what is the next step if there is an 829 denial. be it based on an issue with the path of funds or project-based or something like that.
Yeah.
So I think that, you know, the thing to keep in mind is that if there is an 8 to 9 denial, then eventually the government is going to place the individual in proceedings. And at that point, if the denial was because of something like the path of the funds, the same arguments that were put before the agency in the 8 to 9 petition can be put before the immigration court in removal proceedings, right? So, you know, those types of cases have a chance of success there because, you know, you can sort of try to explain about the discrepancy in policy and why this, you know, is not appropriate to bring up at this stage and those types of things. Of course, it's harder if there's a project-based denial, right? Because if the jobs, for example, were not created, there's really no argument, you know, to be made there. And for those, really, you know, we would need to be talking about other strategies because obviously the concern at that stage is that we have investors and their families that have lived in the U.S. for many, many years at that point. Their kids are, you know, they think of themselves as, you know, maybe not, you know, U.S. citizens, of course, but Americans, you know, for sure, because they've been in the school system, they have friends, they have life. So it becomes a lot harder, you know, at that stage, right? We have to think about other strategies to help them continue to be able to, or get back their ability to be able to be permanent, you know, residents once again.
So what we can do to be able to help them to get back to the residency status again after the 8 to 9 application?
So, well, you know, there is, of course, as we talked earlier, there's the ability to make another EB-5 investment. We have now, under this new law, again, we'll talk about in a bit, the ability to file petitions under the certain visa set-asides that are adjudicated on a fast track in comparison to what's happening with the other petitions. And that will allow, of course, to get back eventually the ability to be a conditional and then permanent resident. Wow. Alternatively, there are other, you know, ways that are employment-based, right? So, you know, we could think about work-based visas or, you know,
H-1B, EB-3.
Well, EB-3 is this employer green card sponsorship, right? That's not a visa, but like an H-1B, for example, or something of that nature. A lot of the investors from Vietnam also tend to have Australian citizenship as well, we have noticed. So, you know, for people who are Australian citizens, there's a special visa for work. It's called an E3 visa that's only available for Australian citizens. But something of that nature, getting them into a work-based temporary visa that will give them that sort of temporary ability to stay in the U.S. and be working and then reassess and think about the next steps. The one thing, of course, this leaves, right, and I know those of you watching at home are thinking, because the kids at that point are going to be of an age where they're going to need to have their own visas as well. So that will also need to be thinking about, you know, if they're working at that point, you know, can we get them an H-1B or something like that through an employer? You know, and it's really a a planning issue with the investor and the family.
The fact that a lot of EB5 investors, they don't really find a job in the US to earn for their living, but they may base on the income from Vietnam, for example, to support for their family in the US. So find a new job to sponsor for H1B is not easy for them.
It's not. It's not for everyone. It might be the strategy for their children who are in the workforce, right? But certainly this is where considering making another EB5 investment and going under one of the set-aside visa EB5 subcategories would be something to consider.
Oh, so I have another question. For those investors who do not expect the 829 petition be denied, and that's why they don't plan to find a new job ahead before the denial. So what if their 829 denied and they need some time to find a job? During that period of the time, can they still legally reside in the US?
So I think before I answer your question, it's important to step back and to say that there's not going to be we're not expecting a giant number of these types of denials. So this is not going to be an overwhelming type of problem, right? So this is, if those denials do happen, we're talking about in that event, what do we do? And if there is an 829 denial, then individuals will have the right to continue to reside in the US until such time that an immigration judge has found that they're no longer conditional permanent residents. So just the 829 denial in and of itself doesn't do that. They can be here until there's determination made, a final determination, which is generally made by the immigration court, or there's an appellate body there too, that they are no longer, permanent residents of the United States. So in the meantime, absolutely, they're, free to, they can't travel internationally when in removal proceedings. They have to be inside the U.S. But while in the U.S., they can look for a job. They can travel, internally within the United States. They can live their lives as they were, and it's not an issue.
I see. So in what circumstance the immigration court will actually look to their individual circumstance to determine that they are not permanent resident again and do some forth to removal proceedings, something some action to move there out of the US?
So these types of situations tend to, our immigration court system is incredibly, we talk about the EB5 petitions being backlogged, right? And processing times for 829s and things like that. The immigration court system is way more backlogged than that. So even for EB5, if for the small percentage of people where the 829 does get denied, it takes a very long time for them to even be placed in proceedings. And then once they are placed in proceedings, it takes years. Years and years and years and years for them to even have their hearing, because the immigration courts are backlogged many, many years back. So this is, again, for the small group of people to whom this would apply, it is not like you get an 829 denial and you pack your bags because tomorrow you have to go into a court and the day after you're not a permanent resident. it is going to take a very, very long time. In the meantime, right, if things happen for the investor, like, you know, oh, I've been waiting for my hearing date and it's like still 5 years away, you know, maybe I make another 526 investment and file another, you know, 526E, and just once that's approved, because, you know, obviously somebody is, you know, trying to figure out a way to file again. Once that's approved, file another application for conditional residence, or if already in removal proceedings, try to see if there's a way to make another adjustment of status application in immigration court. Or some people are going to say, you know what, I'm just going to abandon what I have now because I'm sick of waiting, and I'm going to process through, you know, the immigrant visa process, because my petition has been approved so quickly that I can do that, and it's not, you know, a lot of delay. So, you know, it's something that we can talk about as it's happening.
Yes.
But again, these things can take many, many years. And while someone's in proceeding, we would figure out ways with them to make a strategy that can be put into place to even avoid that final determination that somebody, you know, is getting removed or something.
Yeah. So for those investors who have issues or questions about 829 denial, please contact to your lawyer to seek for the advice on the strategy how to do after the case get denied.
Right. And again, to stress, right, these are not inevitable, right? It's not going to definitely happen. These denials are few and far in between.
Yeah, but it's good that for the investor who get 829, they still continue living. They still be able to continue living in the U.S. before the removal proceeding actually happen.
Yes. Yes.
Thank you very much, Nataliya.
Of course.